Sam Seder on the Majority Report. Pleasure to welcome back to the program Mark Joseph Stern, Slate senior writer, who of course covers the Supreme Court and is co-host of the podcast Amicus or Amicus.
Amicus.
You pick your choice.
My official title is co-pilot, and we say amicus in our corner of the world. But you are allowed to say amicus and be wrong.
Of the world.
Is it co-pilot or co-pilot? All right, doesn't matter. Moments ago, we just heard that the Supreme Court stayed an order to rehire some segment of the federal workers. I don't know if you've had a chance to look at that. We might as well start there and just work back, because the past 24 hours there's been a lot of activity on that. Begin to give us a sense of where the Supreme Court's going to fall on stuff that's really, I think, it's sort of shocking even for them, or maybe it isn't. But let's start with that first ruling that just happened.
Yeah, so the Supreme Court blocked a lower court order that had required the federal government, as you said, to rehire about 16,000 employees who were probationary, which just means basically that they had been hired within the last year, or they had been promoted to their position within the last year. When Trump came in, notoriously, his Office of Personnel Management, which is basically the federal HR bureau, ordered these agencies to just indiscriminately fire almost all of their probationary workers. The Office of Personnel Management has no power to do that, which is why the federal judge here blocked the mass terminations. But the Supreme Court just stepped in and froze his order, entirely based on standing, not the merits. And I understand why. So the plaintiffs here were a group of organizations, like nonprofits, that claimed that they worked with the government, and that by firing all these probationary workers, the government would be unable to meet the needs of these third-party organizations. And the Supreme Court basically said, by what seems to be a 7-2 vote, that those organizations did not have standing to file this lawsuit. So we have to go back to the drawing board. It's a really big blow to these employees. I will note some of them are covered by a separate injunction by a federal judge in Maryland, but it is nonetheless certainly a setback in this case.
Is this the only case that's been brought on behalf of these probationary employees?
No. And so the complicating factor here is that the employees themselves and their unions have also sued, but there has been a conflict in the lower court.
Is that in Rhode Island?
That is in Maryland and in California, and I'm not sure if there's one in Rhode Island. Sorry. But the issue here is that there are these federal panels, like the Merit Systems Protection Board, that are supposed to be responsible for resolving unfair and unlawful terminations of federal employees and union members. And so thus far, the federal courts have told the actual employees that have sued, you can't come to us, you have to go to these federal boards. That's why the judge here found that these third-party organizations had standing and said. But the issue is that Trump has illegally fired members of these boards that are supposed to resolve these disputes, depriving them of a quorum and preventing them from actually ordering the rehiring of unlawfully terminated employees. So Trump has sort of put these plaintiffs in a catch-22. They're told in federal court, you can't sue because you have to go to these boards, but then they go to the boards and they're told, we can't do anything because Trump illegally fired us all and we don't have a quorum.
And so are they bringing actions against the Trump administration to reinstate the people on these federal boards so that they can go to the federal boards? And
yes. And just yesterday, the DC Circuit reinstated 2 individuals on these federal boards. But that is this big looming question that's facing the Supreme Court about whether independent agencies can exist. And the Supreme Court is going to have to decide whether or not these individuals can actually be put back in place. And I think there's a good chance the Supreme Court will say no and say that Trump has unilateral constitutional authority to fire anybody he wants from independent agencies under some magical provision of Article 2 that the Federalist Society discovered 20 years ago.
So then these workers theoretically go back to the courts and say, the remedy that was available to us before no longer exists. And so now you got to hear the case because these agencies don't functionally exist. And therefore there's no conflict.
You got it. That is the next step. That is a step the plaintiffs are already preparing. And that is a step that the judge in this case that we're talking about has already basically previewed. He has said from the bench, I think that it is a sham to claim that these employees can go to these boards when the boards have been paralyzed. And I am preparing to issue a ruling on the matter soon. So this case is far from over.
I imagine that judge is now going to be moving even that much quicker, right? Because
yes.
These probationary employees, and again, reminder, when you talk about efficiency and, for government, firing all the people who've been just recently found to be so good that they're going to be promoted, and firing them basis on the fact that they've been promoted because now they're in the new job and they're so-called probationary, suggests like you're not looking for the most efficient thing, obviously. But
yeah, and that's putting it pretty generously. Judge Alsup, who is the judge in this case, he has been pissed off at the government for weeks now because the government falsely told him that OPM, this HR department, wasn't directing these firings. And it was a lie. It was just like a brazen lie. He called it a sham and said it was a fraud. And he tried to make the Trump official who submitted this perjured testimony actually appear in court and testify on the stand, and he refused to do so. So this case is a huge mess, and the judge is kind of like out for blood. And I think it's very possible that he will issue another decision that protects these employees again soon. Of course, then that rockets back up to the Supreme Court, and we just have a version of this conversation for the next 4 years.
What I don't understand too is, I mean, I understand the standing question, the Supreme Court, but it also feels like in the past, when you've gotten like emergency orders from the Supreme Court, the primary issue, it seems to me, has always been how much of, if we allow something to stand or not stand, how prejudicial is it and how sort of reversible is it? And this will get to the issue, I think, the next thing that we're going to talk about. But it seems to me like these probationary employees, all the employees that basically that have been fired by DOJ, some have been reinstated, some not. But like, you can't live in this, like, people can't live in this, I don't know if I have a job today versus tomorrow the next day versus the next day. You can't live there. Irreparable harm happens, it seems to me.
Yes, indeed. And irreparable harm is one of the factors that the Supreme Court is supposed to consider when it issues these decisions on the shadow docket, right? It's actually not supposed to be nitpicking the merits or standing or anything else. One of the big questions is who is going to be harmed if we don't intervene? And as you just noted, I think it's questionable that the government would be harmed if these probationary employees simply stay on the job for a few more weeks or a few more months. And it would indeed grievously harm them to be unlawfully fired by an HR department that has no legal authority to fire them. I mean, just to be clear, like, there is a federal statute that lays out how agencies can undertake a so-called reduction in force. There are federal statutes that lay out who can be reduced, who can be terminated, who can be laid off, and how. And the administration didn't follow those laws, like, at all. They didn't even pretend to follow them. So this is an illegal mass purge, and one would hope that the Supreme Court would see that the victims of an illegal mass purge face more irreparable harm than the government that is forced to actually comply with the law. But that is not the Supreme Court that we have.
Okay. And I think we see a similar perspective when it comes to the next case. This one was, I guess, decided. Is that the word that we would use?
This is a decision.
That last night, this is a 5-4 vote on the question of the president's use of the Alien Enemies Act to send 300 people, which we now know like 75% of, at a minimum,
no criminal record.
Probably more.
And probably more, but like definitively we now know
CBS
at least 75% of them have no criminal record.
Yep.
But even if they did, frankly, without due process. So like, walk us through what case arrived there, what was happening? Because this is the case that Justice Boasberg was dealing with throughout the entire process, it seems like.
That's right. So on March 14th, Trump invoked this law from 1798 called the Alien Enemies Act, that is a law that by its own terms can only be used in wartime during a conflict with a foreign nation, that applies to invading soldiers of that foreign nation. We are not at war with Venezuela, and this Venezuelan gang that was targeted, Tren de Aragua. It is certainly not the Venezuelan government, but Trump nonetheless declared, we're at war with a Venezuelan gang called Tren de Aragua. These members of the gang, alleged members, are foreign soldiers invading our territory, and Trump purported to claim the authority to summarily deport them without due process. So on March 15th, before he even published this proclamation, he hustled these migrants onto planes and then sent them to this mega prison in El Salvador, accusing them all of being terrorists. And as we've discussed, they are not terrorists. They are not even criminals. Many of them were here lawfully or seeking asylum and waiting for their cases to be adjudicated. And yet the Trump administration deported them to this prison in El Salvador. The judge you mentioned, Judge Boasberg, he issued a temporary restraining order in the middle of all this on March 15th, saying you have to turn around the planes. This is an illegal act. The Trump administration refused, defied his order, and we have spent the last few weeks dealing with both the merits of this case and the fact that the Trump administration will likely be held in contempt of court. And Judge Boasberg is now on the brink of doing that, but the Supreme Court has just thrown in this curveball by, and we can talk about it, essentially reversing everything that Boasberg has done so far and saying that this case has to be dissolved.
Did Boasberg address the invocation of the Alien Enemies Act on wartime grounds, and did the Supreme Court address that issue?
So Boasberg issued his temporary restraining order on the grounds that the government likely cannot invoke the Alien Enemies Act in this way, that the government is not at war with a gang in Venezuela, that gang is not, in fact, a foreign nation, all of this really obvious stuff. He also held that individuals who are targeted under the Alien Enemies Act have a right to contest their classification, basically due process rights, and that the government didn't provide that here. And so Boasberg issued this temporary restraining order, and it was a class-wide order. So it was like a class action suit. And he said, none of these individuals targeted under the Alien Enemies Act may be deported to El Salvador because this invocation is likely illegal and they've been denied due process. That is the temporary restraining order that the Supreme Court dissolved on Monday night. But in doing so, the Supreme Court did not address the merits of the case. It did not address the Alien Enemies Act. It did not address the questionable, at best, invocation of this wartime law. All it said was that the plaintiffs filed in the wrong way in the wrong court, and sort of just obliterated all of the proceedings that had gone on so far protecting these migrants.
Okay, so just to be clear about the last part, because Boasberg does two things. One is he makes an assessment as to whether the ability for the president to invoke this is legitimate.
Yes.
Whether there was any people that he had deported or not, it still could have been a question for him to address.
Exactly.
Under what circumstances. And then secondarily, even if it was legitimate invocation of the Aliens Act without an invading force, and the way it was executed in the case of these migrants was also illicit, even if you could invoke that. And so the Supreme Court doesn't address either one of those things?
So it sort of addresses the second thing. What the Supreme Court does, as I said, is dissolve the restraining order. And it says that these plaintiffs, rather than filing as a class in federal court in DC, challenging this entire program, they have to file what are known as habeas petitions, one by one, in the federal district where they're being held. So for those who are still in the United States, that is in southern Texas, which is a district packed with Trump judges. And of course, it's within the Fifth Circuit Court of Appeals, which is a super Trumpy circuit. So the Supreme Court shifted all of this litigation from class-wide litigation in a friendly court to individual, narrower litigation in a much Trumpier series of courts. But this is key. It had this sort of consolation prize, I guess you could call it, where it did sort of affirm Judge Boasberg by saying aliens have a due process right. They are not to be denied due process under this law or any other law. And so the majority went out of its way to say the government has to afford these aliens notice and a hearing to contest their classification and deportation before it flies them out of the country. Now, we should ask whether that will have any real meaning or effect, given the way that the court has trapped them in these very narrow habeas proceedings. But at a bare minimum, the court affirmed that the Trump administration can't simply say they're terrorists, they have no due process whatsoever.
Can we just talk before we get to the other aspect? The idea of denying the ability of these people to participate in a class when all of the language is literally about them in a class being mass deported. Yeah. This is not like, these are specific instances. Like, you are, and correct me if I'm wrong, but in invoking the Alien and Enemies Act, right? Because this isn't about deportations in general. This is about deportations under an act where you essentially say, we're at war with a country. You have to specify the country, right? I mean, you can't theoretically deport non-Venezuelans if we're at war with Venezuelans or people who aren't associated with like the supposed enemy. You're establishing the class. Yes. You're establishing that they're all subject, by being members of this class, to this type of treatment. Like, this is about and we should say that as opposed to in civil procedures, like a multi-district legislation or a mass tort, they are all subject to the exact same punishment or harm, as it were. Right. And they're denying a class. I mean, this is sort of like the classic way that the Supreme Court will bar entry into the courts and make it harder for individuals to pursue their rights.
Yes, a couple things. First, I mean, the plaintiffs might still try to file some kind of class-wide habeas action. The problem is that the Supreme Court has never actually approved of any kind of class-wide habeas action, and these district courts in Texas will not be the first to do so. So it's almost guaranteed that, as you said, this group of people who are identified and targeted as a class are nonetheless going to be forced to litigate this by themselves, like 300 different petitions, as Justice Sotomayor said, all toiling away. They're going to need a translator. They're going to need lawyers. They have been, I fear, set up for failure. But beyond that, habeas is, I don't want to get too much into the Latin or the Magna Carta or whatever, but habeas is literally a lawsuit against the custodian or the warden of the prison where you are being held, saying that you have a legal right to be let out. It does not make any sense for these migrants because they are not asking to be let out of ICE custody. They are not asking to be let out of the detention center in Texas. They are saying the exact opposite. They want to stay in the detention center in Texas. They do not want to be sent to a different prison in El Salvador. And this is why I think Barrett dissented, by the way. She dissented with the other three women. She did not join a lot of Justice Sotomayor's opinion, but she joined the part about habeas not being the right sort of procedure here. And I think that's because, when she was at University of Notre Dame Law School, she was a professor of legal procedure. Her specialty was civil procedure, which involves class actions. She knows this stuff like the back of her hand. And she surely recognizes that the idea that this class of people cannot file this class-wide action in DC and that they have to file these individual habeas petitions, it's just wrong on the law. And for the Supreme Court to be making up new law on the shadow docket that is substantively erroneous was a bridge she would not cross.
So let's move on to the second issue. How much did they address the fact that the Alien Enemies Act has been invoked 3 times, if I remember correctly? 1812, the War of 1812, World War. Let's see if people can see the consistent element in this. World War I and World War II. What is and I guess there's some question as to like what constitutes a war, what constitutes an invading force, but it feels like anybody with half a brain would realize that we're not being invaded by Venezuela. I don't even know if you could find a percentage of what amount of our crime is committed by Venezuelans, but I imagine it's not that high to constitute an invasion and an occupying force. And these people were not that, but we've already determined that as individuals, they're due, I guess, some due process. But what about the invocation? Did they address that at all?
Nope. They did not address the likely unlawful invocation of the Alien Enemies Act. The majority opinion was 4 paragraphs. The majority opinion barely said anything at all. It said something wrong about habeas. It said something cursory about due process. And then it basically said, screw you, Judge Boasberg. We're throwing you under the bus. I mean, there was very little explanation here. And I think that is deeply unfortunate because if the court was going to address the merits, you'd kind of want them to get into, wait a minute, why is this law that was last used to punish Nazi saboteurs invading the United States during World War II suddenly being repurposed as a deportation law? And I just want to be clear about something. There are a bunch of federal statutes that allow the administration to legally deport people. The administration has been legally deporting Venezuelan migrants during the pendency of this litigation. It can do this the right way, the right way. It is not doing it because it wants to assert this power under the Alien Enemies Act. And this is something that Justice Sotomayor pointed out that I do think is worth lifting up at this point. If the government's argument is correct, that under this statute, it can abduct a person off the street, accuse them of being a foreign terrorist or enemy combatant, and then send them to a foreign prison with no due process, it doesn't stop with migrants, right? The government could do that to American citizens as well. American citizens would have no opportunity. They certainly did it with
legal migrants.
Yes.
That we found out subsequently. I mean,
they've already done it with legal migrants. They can do it with citizens.
And Trump just said it on the plane on Air Force One. We played that yesterday where he said that this is something he wants to look into. Can you flesh that out a little bit more, Mark? The differences in terms of the authorities at issue here with the Alien Enemies Act and traditional modes of deportation? Yeah,
I mean, we have these deportation laws that are pretty generous to the government, that give the government the ability to deport many, many, many migrants who are here in this country, some without authorization, some who have temporary authorization, some who are seeking asylum, but the Trump administration will almost certainly deny their asylum claims. And it is not difficult for the government to deport those people under these civil statutes. And again, it has been doing so, but it just didn't feel that it was happening quickly enough. I don't know if you remember earlier, in March, there were some of these articles saying Trump officials upset at slow pace of deportation. The White House wanted to make a splash. They wanted to create the impression that it was doing these summary deportations. And I think that is why it decided to draw upon the Alien Enemies Act. But that, of course, does not make it legal just because it was politically expedient.
Can any one of these individuals return to Boasberg's court and say, hey, okay, I'm due my habeas corpus. Well, obviously they're gone, but maybe somebody can bring, or one who was shipped out or whomever has standing. Can they bring it has the court not addressed the actual invocation enough in this ruling that they could actually, Boasberg could do a redo on just, how severable are his injunctions, I guess?
Okay, so I think here's the problem. The court said, simple solution, you file where you're being detained. The problem is that hundreds of people are already being detained at the CCOT mega prison in El Salvador. There is no federal district court in El Salvador where they can file their habeas petitions. They are out of the country. According to the Trump administration and the Justice Department, those people have no legal recourse whatsoever. According to the Justice Department, once a migrant has been deported to another country, that person is in the control of a foreign sovereign. They have zero constitutional rights. Their due process has been extinguished, and they have no freedom to file a habeas petition anywhere. They're just done. They have been disappeared to a black site, and the government has no ability or responsibility to bring them back. Now, I think that has got to be wrong. There is a petition before the Supreme Court raising this question in the case that you mentioned, the case of Kilmar Abrego Garcia, who was protected against deportation and wrongfully sent to El Salvador. He is awaiting adjudication from the Supreme Court. It could come at any moment. But there are, of course, others there, perhaps his cellmates in CCOT, who have the exact same problem. Some of those individuals might now try to file before Judge Boasberg saying, hey, we don't know where we should file these petitions because we don't have a federal district. We're in El Salvador. So we're going to go with you because that's where the federal government is located. I don't know if that'll work, but I think that's a likely next step.
Well, what about, why couldn't any Venezuelan do this? Because if you are in the United States, presumably the invoking of that act and the reference to Venezuelans means that it's really, you are under the auspices of, right? Like what's to prevent them from finding any other Venezuelan who has legal protected status? They have proof that can happen to them, and not bring injunctive relief against them being subject to the Alien Enemies Act.
Well, I think as our discussion of that illegal purge case showed, the Supreme Court loves to weaponize standing doctrine to avoid issues it doesn't want to address. And I think that if just any Venezuelan migrant came forward and said, I'm afraid of being targeted under the Alien Enemies Act, the courts would probably say, you don't have standing. You have to wait until you're actually targeted, which is a horrible catch-22. Because then once they're targeted...
But it also feels like you're being targeted. If you're
right.
a Venezuelan, then you are subject to more scrutiny, period, it seems like. But
I am speaking not for myself, but for our captured courts.
I mean, is there any precedent that backs this up? Is like, and I'm curious, like in the Bush era, this complete erosion of habeas corpus rights as it related to folks who were grabbed by the administration during the war on terror. Like it just occurs to me that they're basically saying they don't have standing, probably because they're not American citizens, and they also don't have habeas corpus rights. What rights do these people have?
Right, which is a terrifying argument, right? Because again, as Judge Patricia Millett said when this case was the D.C. Circuit, there is nothing in the government's reasoning here that would stop them from abducting her or you or me or anyone and sending us to El Salvador and saying we don't have any more rights. So, I mean, the Bush administration tried this with Guantanamo, but of course the Supreme Court, a very, very different Supreme Court, held that Guantanamo detainees had habeas corpus rights because they were under the control of the U.S. government. That decision is why we are here today. The Trump administration learned from the Guantanamo example and said, well, we have a solution. Rather than sending people to a naval base that we control in another country, let's just send people to a prison that we don't control in another country. And then argue that once we've deposited somebody in that prison, they're outside American jurisdiction, they're outside our control, they're outside the jurisdiction of a federal court, and there's nothing anybody can do. I think that is wrong. There is a premise in the law, a concept known as constructive custody, that says that even if somebody is not in the control of the government, if they have been placed in custody at the behest of the government, then the U.S. government still has to answer to their complaints. And so here, what Abrego Garcia is arguing, for instance, this guy who was wrongfully sent to El Salvador, he's saying, look, the U.S. government is paying the Salvadoran government to keep them here. The U.S. government has a financial and legal agreement to keep these individuals in CCOT. So clearly they are under the constructive custody of the U.S. government and can be sent back. But, John Roberts was picked to be Chief Justice because he opposed the rights of Guantanamo inmates. Like, right. Brett Kavanaugh made his name as a lower court judge turning away Guantanamo detainees' appeals. Like, it's a very different Supreme Court, and I think it's kind of hard to count to five to get there.
Let's move on to cases that haven't been much in the news because of all of the horrible things that have been in the news for a moment. Kerr versus Planned Parenthood. On its face, it looks like an abortion or an anti-abortion case, like a religious freedom case, I guess. But it's highly problematic beyond that too. Give us the details on this case.
So South Carolina and many other states are defunding Planned Parenthood clinics because they perform abortions. They are denying them Medicaid dollars. They're telling Medicaid patients, you can't get services at Planned Parenthood. The problem, of course, is that patients cannot get abortions with Medicaid, right? There's a federal law that prohibits it. So all these states are doing is preventing patients from getting the entire range of other care, like STI screenings and cancer screenings that are provided by Planned Parenthood. The issue there, aside from the fact that it's immoral and abhorrent, is that the Medicaid statute that Congress passed says that patients have a free choice of provider, that they get to choose a qualified provider, and that if they are denied a free choice of provider, they should be able to vindicate their rights in court. The Supreme Court will decide whether or not that's true. The Supreme Court in this Kerr case will decide whether a patient who is cut off from their care because the state has a political vendetta can go to federal court and say, my rights have been violated. If the Supreme Court says that that's not allowed, it will give red states vastly more discretion to start defunding medical providers that they have an ideological or political grudge against. And I think it would really tear the Medicaid statute into Swiss cheese, because it would suddenly give states this vast new authority to deny Medicaid reimbursements to any doctor they don't like, even though Congress made it very clear that that was not what they were allowed to do.
I would also go further that, and I just want to make this clear so that people understand, Medicaid does not pay for abortions at Planned Parenthood.
Period.
Planned Parenthood is not necessarily, even in some of these states, providing abortions. They are just providing health care.
Yes.
It's illegal under the Hyde Amendment.
Yes.
But some of these states, abortion is outlawed. They are not performing abortions there. They are
Correct.
just providing. So not only could states do this by saying we're going to make. We're not going to allow Medicaid to pay for services at Planned Parenthood. They could also say, like, hey, these doctors were top donors to Democrats.
Yes, exactly.
One of my biggest donors is, Metastop and Medicaid. The only place that we allow Medicaid to basically pay, because we've said you can't, the other is Metastop.
Yeah.
The amount
just
of
to be clear,
corruption that can happen here seems to be extraordinary.
Like, this was starting to happen under the original Medicaid statute, and Congress came back and revisited it and gave patients this right to choose their provider so that it wouldn't happen. And yet here we are with the Supreme Court deciding whether or not Congress did that. And I think it could, I'm cautiously optimistic the court will come out the right way, but it could
Because it
well
was so
be
explicit.
5-4. It's so obvious, yet it could be 5-4, because Brett Kavanaugh was actually saying, well, there are magic words that Congress needs to use. They need to use this specific language saying they have a right. And they didn't say they have a right. They said they have a choice. They said they have a privilege. Where's the magic word? This is the problem with putting an intellectual mediocrity like Brett on the Supreme Court. Like, this should be so painfully obvious, but he is pretending like it isn't.
Is that about intellect, or is that just simply about, the lack of intellect could provide for the lack of shame. But
Yeah.
at the end of the day, whether he's smart or not, he knows what he's doing,
Yeah,
right?
that's true.
They're assaulting Medicaid, and whether he can come up with a clever justification for it or one is really sort of like secondary. That's just a question of shame, and he knows when he gets to the country club, they're not going to care anyways.
Yes, that is fair enough. Shamelessness is a superpower of the conservative justices across the board.
When are we going to hear a ruling on that? This has big implications for Medicaid, right? Because this is also a way in which you can boot a lot of people off of Medicaid, functionally speaking, because if you only allow healthcare to take place in certain outlets, you can make it much harder for somebody to go for an appointment if they live 3 hours outside of the nearest provider.
Oh yeah, you could say only Columbia Hospital gets this Medicaid reimbursement. So everybody who lives in Charleston and other parts of the state, you're just going to have to drive hours if you want your healthcare, which is a similar play that they did when shutting down abortion clinics. So it wouldn't be surprising. we should expect a decision in June. This is a case where I think that the fear has always been, it's about Medicaid, it's about Planned Parenthood. The conservative justices hate government spending and hate abortion, but a bunch of medical associations and hospital groups and like medical lobbyists have weighed in to try to explain to the more sort of Chamber of Commerce oriented conservatives, like, this is not the case you want to use to carry out your grudges against Planned Parenthood. Like, this is actually an extreme danger to the medical establishment. And I'm hopeful that at least Amy Coney Barrett and John Roberts will hear that. I'll also note that, like, South Carolina hired these anti-abortion activists to argue the case for them. So I think it's pretty clear that this is not really about states' rights. Like, this is about a relatively small group of extreme and corrupt ideologues trying to manipulate Medicaid for their own ends. And hopefully that will be clear enough to 5 justices, but it's not something I would put money on with this court.
Well, it also scares me that they took it, because usually they'll take a case that would if they want to go after Medicaid, they would do one with that was a little cleaner, it feels like. But maybe they're attracted to the religious freedom.
I mean, there was a split. There was a circuit court that had gone the other way, the Fifth Circuit, of course. And so, they usually feel they need to resolve a split. And I think that was their reason for stepping in.
Since we're at it, let's just do this last one. The Voting Rights Act, to the extent that it's like still functioning, this Supreme Court for the past now 12 years has been assaulting the Voting Rights Act starting in 2013, I think it was, right?
Yep.
Where, and this has been John Roberts, really, lifelong agenda. He wanted to go after the Voting Rights Act when he was an OLC, I think it was, or maybe a civil rights
the Justice Department.
In the Justice Department under Ronald Reagan. This latest one is a combination of 2 cases. Louisiana v. Calais, or I don't know how we're pronouncing it, from New Orleans or Louisiana. But what is that case?
Yeah, this is a puzzling case because you may remember, like, it was less than 2 years ago that the Supreme Court actually saved the Voting Rights Act. John Roberts and Brett Kavanaugh decided to go with the 3 liberals and say, we're not going to execute what remains of the Voting Rights Act. We're going to allow it to stand. And I'm really not sure what the point of that was, because now in this Louisiana case, it looks like they're both ready to go ahead and drop the guillotine. So this is a case about Louisiana's congressional districts. Louisiana, after the 2020 census, drew a congressional map that only had 1 majority Black district, even though there are many, many, many Black people in the state. A federal court said this is diluting the votes of racial minorities. You need to draw another district that at least plausibly gives Black people representation. So the legislature did that, actually. It complied. And then these white voters sued the state and said, this new district that you drew, it gives Black people too much political power. And we think as white people that is offensive. And so they filed a constitutional lawsuit arguing that it violated the Equal Protection Clause. And that's the case at the Supreme Court. And so the only question for the Supreme Court should be, were we correct to save the Voting Rights Act 2 years ago? It's the same, pretty much the same justices, right? Actually, exactly the same justices. And if so, then should we allow Louisiana to have complied with this court order saying draw 2 Black districts? But instead, all 6 conservative justices lined up to bash the legislature for complying with the court order, telling it to draw the 2nd majority Black district and suggesting that it violates the Equal Protection Clause because it gives Black people too much power. That is the exact argument that the court rejected 2 years ago. It is a bizarre manipulation of equal protection precedent. I don't understand the point of the court going back on itself, but it does look like the court could use this case to essentially just execute the Voting Rights Act and say that when legislatures draw districts that are specifically designed to accommodate for Black voting power and give Black people representation, that effort is even if it's compelled under the Voting Rights Act, that it violates the Equal Protection Clause of the 14th Amendment and has to be struck down.
Do you think that there is a like a chart in Roberts' office, maybe behind like a picture of Hugo Black or something like that, that just basically outlines this is the way we're going to do it. I have like a timeline so that it doesn't look too extreme. And that's what's going on here.
Yeah, I mean, he definitely has a plan in his head for how you dismantle precedent, right? And, you know, that 2013 decision you mentioned, he teed that up a few years earlier. He loves to sort of plant these seeds and hide these landmines in his jurisprudence. I think here, maybe he consulted his chart or his star sign or whatever. I guess he's decided it's time for the Voting Rights Act to go kaput. I mean, maybe I could be surprised. I was 2 years ago. There's a chance that somehow the Voting Rights Act gets a stay of execution. But they all the conservatives sounded pissed off that Black people have fair representation in Louisiana now and ready to strike down this map. So I maybe his star sign says that it's time for the Voting Rights Act to be put to bed.
Is there any other case that's happening across? I mean, we have like, I don't know, 80, 90 cases that have been lodged against the Trump administration. Maybe it's more now, whether it's ranging from like the executive orders over voting or these firings and I mean, it's endless. Is there any case that you've been tracking that you think is like one of the most important ones that we don't really hear much about?
Well, we've stopped hearing about the birthright citizenship cases, but that is because they have now been pending at the court for a little while, the Supreme Court. So the Trump administration went to the Supreme Court and asked the court to radically narrow these injunctions against Trump's order stripping birthright citizenship from the children of undocumented immigrants and also the children of visa holders who are lawfully present in the United States. The court has not taken action yet, and someone's writing a dissent. I don't know who it is. I hope it's Sam Alito and not Sonia Sotomayor, but the court will very soon rule on that, and that will reignite, I think, the debate and the coverage around this issue. This is one of Trump's most anti-constitutional policies, and he issued it on day one. And I think it would be a good time for the Supreme Court to send a signal that there is a limit to the lawlessness, but after what happened last night, I'm not super optimistic.
Oh, well, that makes me not super optimistic. Mark Joseph Stern, Slate senior writer, covering the Supreme Court and co-pilot of the podcast,
got it.
Amicus or Amicus, depending on where you sit. Thanks so much for the time today. I really appreciate it.
Thanks, Sam. Thanks, Emma.
Thanks, Mark.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.